We have our esteemed guest speaker. I first got in contact with her when I was the chair of law students and law schools for AILA National. One program I wanted to do was to bring together expert speakers in different areas of immigration law. She's the expert on litigation. That's how I first got to know her. And then over the years, we went to AILA conference together, and then we actually worked on several high profile cases. With that being said, you can take it away.
When we want to litigate a case, we want to make sure that we've done our due diligence on our side to make the government look as bad as possible, right? We're the innocent parties here. We've done everything that's available to us. We've tried expedites, we've reached out to the contact center, no one's responding to us. And so what are you left with? The federal courts. So a mandamus action, right, is when something hasn't been decided. You're waiting for a decision to be made, and the agency has gone beyond a reasonable amount of time in making the decision or taking the action that they need to take. Everyone kind of calls it mandamus under one big umbrella. You can actually sue for the unreasonable delay under the APA as well, which is the Administrative Procedure Act. A mandamus as a statute itself is when there is a time frame specifically prescribed in statute that the agency is supposed to act on. The APA is kind of the catch-all for all the other areas where there's no specific time frame. All we have is a case many years ago that said Congress wanted immigration cases to be decided within less than 180 days. USCIS always points to their processing times that they post on their website, which I'm sure all of you know at this point don't actually reflect anything as to what's reasonable. And when I sue, I look at the historic processing times that they post on a different section of the website that looks at how much time did it take on average to actually adjudicate these, not what their standard processing time is. If it's above that, I say you're well within your range to sue for action on a mandamus case. Most of the time, because the government doesn't want to admit that they've taken an unreasonable amount of time, you file the lawsuit, and within 60 days, sometimes with the 30-day extension tacked onto that, they'll approve the case. Most of the time for a mandamus or APA litigation, you don't actually get to a judge making a decision on the case. The government kind of backs down so that they don't have to justify that, or they don't get to a discovery stage where they look at, well, is it reasonable that you're taking this amount of time to adjudicate cases? The other side of litigation is when you've actually received that denial. Put in all the work, you've done your due diligence to put all the documents out there that USCIS has asked for, and they still say, sorry, you haven't provided enough evidence, or they're interpreting a policy or regulation some way that you think is not reasonable within the statute. And that's where this new Supreme Court case kind of breaks things open for immigration on a wider perspective of what kind of effect this has, right? They're looking to really take away agencies' ability to make decisions. Can have some negative effects. But for immigration, we're gonna take the win for now, in that previously this Chevron case gave agencies deference on questions of law. So facts, still, even with this decision, if it's a factual determination you think was determined incorrectly, the agency is still unfortunately going to be given deference unless the court doesn't think that the agency or the lower court built up that factual record enough for them to have made a reasonable decision. So they won't actually determine factually something that was wrong, but a court can say, we don't think there was enough of a factual record there for you to make the decision that you did. For our other cases, or if there's a question of law or policy, regulation, something that USCIS has interpreted, previously it was, well, as long as the interpretation is reasonable, then they would give the agency deference in the decision that they made. But now it has lowered that standard to something called Skidmore deference, which is a different case that kind of set the standard for, okay, what kind of decision has the agency made and what is the rationale that they have given when they made this decision. So it's much easier for a federal court to come in, look at the reasoning behind why an agency made a decision and say, you know what, we think we're going to renew or review this de novo, which means as if it's a new case in front of them, and not look at what the agency said, depending on what the reasoning is in the decision that they made to issue that denial. So where does this have implications? anywhere, right? The possibilities are endless right now. It can be applied to immigration court, it can be applied to USCIS, it can be applied to CBP decisions. The possibilities are really endless right now as to what you can challenge. The one caveat that the court did say was if a circuit court has already made a decision of law based on Chevron deference, you can't go back and look at those decisions again, but there are new ways that you can potentially interpret previous decisions or challenge them in a different way. That's kind of what the important part of federal litigation is when you decide is what is the record that the court is going to look at. You don't have the ability to add new evidence once you filed that lawsuit. It's totally based on what you presented at the agency, and that's what they're going to review. So you want to make sure you've got everything in there that you think you need to argue that they made an incorrect decision or they were unreasonable or abused their discretion before you go to court. And the 290B would be the way to kind of supplement that if you think, okay, there was maybe something we missed or that we want to add a little bit more of an argument first before we go into federal court. And that's kind of federal litigation.
Wonderful. What is the standard of APA? It can't just be my case was not approved, therefore I'm going to sue you and get it approved.
So for an APA lawsuit, you're looking at a decision that is arbitrary, capricious, or an abuse of discretion. You're looking at the reasoning that they made in issuing the denial, or are they misinterpreting the law? That's where that new standard comes into play. Before is it reasonable? Now it's, well, what's the rationale and does it comply with, you know, what the law says and what that gray area is?
I feel like from the past 5 years, it's because of H-1B fiasco that actually started the whole litigation. People who've previously been approved for H-1B 3 years, 6 years, and then they're filing for extension. Somehow, the administration just keeps on coming up with very strange reasons to deny cases. H-1B and the fiasco that was 2016, 2017 pushed the entire immigration world into litigation. Immigration attorneys had to adapt, and you were on the cutting edge of that invention back in 2016, 2017. And now, with the lowering of the Chevron standard, it opens it up even more, at least right now as it stands. If there's a ridiculous denial, we have that option, that toolkit to be able to hold the government accountable for their decisions. Well, with that being said, enjoy the wonderful Mexican food that we have. We will start eating and you guys can corner her and talk to her between her bites.
Yes, the finger caressing really adds.
Somewhere on the sea,
Right?
it got a little longer, so it seems. I burned out, so to speak. I feel a little light in the light track. I felt a bit of burn, but I came back. Still a little light in the light track.
Today I learned what mandamus is.
Well, it's just like very rewarding, you know, you got to know a lot of strategies about litigation.
I've always been like really interested in immigration just because I'm like an immigrant as well, and then just listening to her speaking how like the process has changed from many years ago to now, like that's like an interesting thing to hear.